Well, good morning. I've been giving presentations like this for almost 40 years, since the fall of 1982 when I left active duty and affiliated with the Navy Reserve, or the Naval Reserve as it was then known. And I took a civilian job for the United States Department of Labor as an attorney. The office I worked in dealt with several laws, but the one that was most important to me then and now, it was known as the Veterans Reemployment Rights Act, a 1940 law that provides that if a person leaves a civilian job for voluntary or involuntary service in the armed forces, he or she had the right to the civilian job back after completing the period of service. It was a good law, but it had become cumbersome with numerous amendments, and in 1994, Congress enacted the Uniformed Services Employment and Reemployment Rights Act, USERRA, as a long overdue update, rewrite, replacement for that 1940 law. The 1994 law was largely drafted by two Department of Labor attorneys, Susan M. Webman and myself. And in that same fall of 1982, after I went to work for the Labor Department, in my Navy Reserve unit in Richmond, Virginia, I gave a presentation about reemployment rights, and I've been doing it ever since. Next slide, please. I invite your attention to www.roa.org/law center. We have more than 2,300, we call them law review articles about USERRA, the Service Members Civil Relief Act, the Uniformed and Overseas Citizens Absentee Voting Act, the Uniformed Services Former Spouse Protection Act, and other laws that are especially pertinent to service members. You will also find a detailed subject index to facilitate finding articles about specific topics. Next slide, please. Well, the Reserve Organization of America initiated this column in 1997, and we add new articles each month. I'm the author of about 90% of the articles, but we're always looking for other than Sam articles by other lawyers. I've recently recruited an understudy. She's about to graduate from Baylor Law School here in Central Texas, and then she'll be going on active duty in the Marine Corps as a judge advocate. And she's written some of our most recent articles, and I'm looking to her and others to take on this task. I'm 70 years old, and I won't be available forever. But we have a great collection of articles. We're adding to it. The Reserve Officers Association, or now the Reserve Organization of America, is the only national military organization that represents the interests of Reserve and National Guard personnel from E1 to O10, and anyone who is serving or has served our country in uniform is eligible for full membership. It only costs $20 a year. You can join online at www.roa.org. But you don't have to be a member of ROA to read these articles. They're available for free to anyone on the internet. There's no toll booth on the road to the Law Review Library. Next slide, please. As I said, Congress enacted the Reemployment Statute in 1940 as part of the Selective Training and Service Act, the law that led to the drafting of more than 9 million young men, including my late father, for World War II. But the law has always applied to voluntary as well as involuntary service. Next slide. There have been 17 United States Supreme Court cases under the Reemployment Statute, 16 under the 1940 statute, and one so far under the 1994 statute, USERRA. In the very first Supreme Court case under the 1940 statute, the Supreme Court held that the Reemployment Statute should be liberally construed for he who has laid aside his private concerns to serve his country in its hour of great need. Sorry for it says he, I can't change history, but of course this law applies to female as well as male service members. It applies in peacetime as well as wartime, but that Supreme Court case was decided just a few months after the end of World War II. Next slide, please. Now more than ever, this statute is important and relevant. More than 1 million reserve component personnel have been called to active duty since the terrorist attacks of 9/11, 2001. Some have been called multiple times, maybe including some of you in the room this morning. Next slide, please. The reemployment statute was originally enacted for the greatest generation who won World War II, but it applies equally to people like you, their grandchildren and great-grandchildren of the greatest generation who are serving today. Next slide, please. USERRA was enacted in 1994 to replace the 1940 statute. It's Public Law 103-353, signed into law by President Bill Clinton on 13 October 1994. It's codified in Title 38 of the United States Code at sections 4301 through 4335. It was enacted in 94. It's been amended and many times since then. We're still working on amendments, trying to improve the law. It's a great law, but there is some room for improvement. Next slide, please. There's next slide. As, I said we have our 2,300 articles, probably 1,600 of them are about USERRA. We have a detailed subject index, especially for USERRA. In the subject index, all the articles that start with USERRA, that are about USERRA, start with the digit 1. Next slide. USERRA applies to almost all employers in this country. It applies to the federal government as a civilian employer. It applies to state and local governments, and it applies to private employers, regardless of size. Other federal employment laws, like the Title VII of the Civil Rights Act of 1964, only apply to employers with 15 or more employees. But the federal reemployment statute has never had such a threshold. You only need one employee to be an employer covered by this law. Next slide. Next slide. It applies to U.S. employers overseas. It applies to foreign employers in the United States. It applies to joint employers and hiring halls. Some people in the reserves and National Guard work in that kind of work. It applies to successors in interest. In other words, if you worked for the ABC company and you got called to active duty, or you volunteered for active duty for, say, 2 years, you came back, and while you were gone, the ABC company had been taken over by the XYZ company, a merger or acquisition of your company by another company. Well, then the XYZ company would be what we call the successor in interest to the ABC company that you worked for before you left for service. So you would have reemployment rights with the successor in interest, the XYZ company. Next slide. The only employers in the United States that are not covered are religious institutions, churches, synagogues, parochial schools, Indian tribes as employers, and foreign embassies and consulates, and international organizations like the United Nations or the World Bank. So there are very few exceptions. Hopefully none of you work for one of those kinds of employers. Next slide. It applies to temporary, probationary, and at-will jobs. Probably 75% of all employees in the United States are what we call at-will. Unless you work for the federal government or a state or local government, or unless you belong to a union that has a collective bargaining agreement with the employer that provides that people can be fired only for just cause, then you're what's called an at-will employee. If you're an at-will employee, you can be fired for any reason or no reason, but not a reason that's forbidden by a specific federal or state law. So even if you are temporary, even if you've just started, even if you're in a probationary period, you have rights under USERRA. Don't let anybody tell you otherwise. It applies to executive employees. It applies to everybody employed by the company, from the janitor to the president of the company. It does not apply to partners or independent contractors, but the label is not controlling. Don't let the employer say, well, Smith is an independent contractor. He doesn't have reemployment rights. Well, they can't make him an independent contractor just by calling him that. That's a legal conclusion. The employer would have to show that the person was an independent contractor or a partner, not an employee. It applies to laid off employees. If you've been laid off with an expectation that you may be called back to work, and then you leave that status to go on military duty, you can have reemployment rights under USERRA. Next slide, please. USERRA does not apply to students, but there's another federal law enacted in 2008 that gives USERRA-type protections to post-secondary students, college students, trade school students who leave an educational program for voluntary or involuntary military service. I covered that in 3 recent 2021 law reviews. Next slide, please. It applies to regular military service as well as National Guard or Reserve service. The great majority of the cases in recent years have been about people serving in the National Guard or Reserve, time off from their jobs for their training and for voluntary or involuntary mobilization. But the law also applies to people who join the regular military and leave civilian jobs. It applies to voluntary as well as involuntary service. Don't let the employer say, well, you know, you don't have reemployment rights, you volunteered. Well, of course, we all volunteer. Congress abolished the draft and established the all-volunteer military in 1973, just when I was starting law school. But all military service today and for the last 2 generations has been essentially voluntary. But you have reemployment rights if you volunteer or if you're involuntarily called up, like a mobilization. It applies to an examination to determine fitness. It applies to funeral honors duty performed by reserve component members. Next slide, please. Next slide. Next slide. Next slide. Next slide. Okay, section 4311 of USERRA provides that it's unlawful for an employer, federal, state, local, or private sector to deny a person initial hiring or retention in employment, i.e. firing, or a promotion or a benefit of employment because of the person's membership in a uniformed service, application to join a uniformed service, performance of service, or application or obligation to perform service, or because of his or her exercise of a right or taking an action to enforce a right under USERRA. Next slide. You only need to prove that one of these protected statuses or activities was a motivating factor in the employer's decision to deny you hiring, to fire you, to deny you a promotion or whatever. You do not have to prove it was the one and only reason. If you prove that your membership in the Navy Reserve, or you're having recently been away from training or service, or your obligation to perform service in the near future, If you prove one of those things was a motivating factor in the employer's unfavorable decision, then the burden of proof shifts to the employer to prove, not just say, that Joe Smith was fired for a lawful reason unrelated to his service in the Navy Reserve. We have a couple hundred articles about this topic in section 1.2 of our subject index of the law review articles. Next slide, please. Next slide. But most of USERRA deals with the right to reemployment. A person who leaves a civilian job for a drill weekend, for annual training, for a voluntary mobile or involuntary mobilization, or even to join the regular military, has the right to reemployment after release from that period of service. He or she does not need to prove discrimination. This is section 4312 of USERRA. Next slide. So to have the right to reemployment, you must meet 5 simple conditions. A, you must prove that you left the job for the purpose of performing service in the uniformed services. If you left your job in December and you didn't go on active duty until the following July, then you would not have the right to reemployment unless you left and there was an unavoidable delay that you could not have anticipated. You have to leave to perform service, and you must have given prior oral or written notice. And tell the employer that you're leaving to perform service. You don't have to cite the law. You don't have to predict you're going to come back. You don't have to do anything except say, hey, I'm leaving because I'm going to perform service. There is a 5-year limit cumulatively with that employer on the duration of the period or periods of uniform service that you can perform relating to that particular employer. But there's also 9 exceptions, which we'll get into. You must have been released from the period of service without having received a punitive by court-martial or other than honorable discharge. So let's have none of this. Let's wake up the prisoners and play the naked pyramid game again stuff, not conducive to getting your job back. And after release from the period of service, you must have made a timely application for reemployment or must be timely in reporting back to work. Next slide, please. Next slide. Next slide. Next slide. Okay, so what do I mean by the 5-year limit? There's your drill weekends don't count, your annual training doesn't count, anything that's involuntary like a mobilization does not count. But you need to keep track of your own 5-year limit with your employer. If you only do your drill weekends and annual training and involuntary call-ups, then you don't need to worry about the 5-year limit because all of those things are exempt. But if you're the kind of guy that's always saying, here I am, send me coach, then at some point you need to worry about the 5-year limit. So it's up to you to keep track of your own 5-year limit if you're going to maintain a career in the Navy Reserve or another reserve component, and if you're going to remain with that same civilian employer. You have to be, after the release from the period of service, if it's less than 31 days, like a drill weekend or a traditional 2-week annual training period, you're required to report back to work the next calendar day after the completion of the period of service, the time reasonably required for safe transportation from the place of service to your residence, plus 8 hours for rest. So you complete your drill weekend at 1600 Sunday afternoon, you should be back at work at 8 or 9 o'clock Monday morning, unless you got a long travel. You know, I know people in the Navy Reserve over the years. I would remember drilling in Norfolk, and one of the officers in our unit came all the way from San Diego, California. If you have a travel after the end of your drill weekend, then maybe you don't have to report back to work till Tuesday morning. If the period of service was 31 days up to 180 days, you have 14 days to apply for reemployment. And if the period of service was 181 days or more, you have 90 days after release from the period of service to apply for reemployment. Now, if you meet the 5 conditions, you left your job to perform service, you gave prior notice, you have not exceeded the cumulative 5-year limit, you did not receive a disqualifying bad discharge, and you made a timely application for reemployment. If you meet those 5 conditions, you are entitled to prompt reinstatement. After a drill weekend or annual training, you show up at 8 o'clock Monday morning, you should be back on the payroll at 8 o'clock Monday morning. If it's like at 6 months or a year or more of active duty, the employer is required to reemploy you within 14 days after your application, even if that means the employer has to lay off somebody else. The fact that there's not currently a vacancy when you come back from your service is not an offense to the employer's obligation to reemploy. Under some circumstances, the employer may have to lay off Bob Williams to make room for you to come back. That's what the law requires. You're entitled to continuous accumulation of seniority for the period of time you were away, for the period of time you worked for that employer, and then continuous seniority for the time you were away until you come back, and continuous civilian pension credit. That's a big deal. You're going to maintain a whole career with the same civilian employer, and you're going to maintain a career in the Navy Reserve or another reserve component, then you must be treated as if you had been continuously employed in determining your civilian pension. For all your drill weekends, all your annual training periods, all your voluntary or involuntary mobilizations, all periods of uniform service that interrupted your employment with that employer. Upon reemployment, you're entitled to the status that you would have attained if you had been continuously employed. The status includes things like location, like being the supervisor instead of the supervisee, like getting to work in the daytime instead of at night, getting to work in that part of the employer where there's better opportunity to be promoted, etc. Next slide, please. In its first case construing the 1940 law, the Supreme Court established what we call the escalator principle. The court held, quote, the returning veteran does not step back on the seniority escalator at the point he stepped off. He steps back on at the precise point he would have occupied had he kept his position continuously during the war. Next slide. This escalator principle is codified in USERRA in section 4316A. It applies to what we call perquisites of seniority, things that are intended to be a reward for length of service, as opposed to a form of short-term compensation, things that you probably would have attained if you had been continuously employed. The escalator can descend as well as ascend. If you worked for a company that was going through hard times and there were 1,000 employees when you left, and by the time you come back 2 years later, there's only 100 employees, 90% of the people got laid off. If the employer can show that you would have been laid off even if you'd not been away for military service, then your escalated reinstatement position, as we call it, may be into a layoff situation. But that's not the situation today. Employers are, desperate to find employees. I'm sure you've seen all the ads. So you are in all probability entitled upon your return from service to at least as good a job as the one you left, maybe a little bit better under the escalator principle. Next slide, please. Upon your reemployment, you're entitled to the rate of pay that you would have attained if you had been continuously employed, perhaps higher than the rate you were making before. You're entitled to immediate reinstatement of your health insurance. If you have health insurance through your civilian job, and then you go away for military service, you meet the 5 USERRA conditions, you go back to the employer, your health insurance must be reinstated immediately upon your return to work. There must be no exclusion of what are called pre-existing conditions, except conditions that the VA, the Department of Veterans Affairs, has determined to be service-connected. You're entitled to adequate rest, travel, and preparation time, both before and after your period of service. I've known people in the Navy Reserve when I was serving who would work all night at a civilian job and then drive to the reserve center, take a shower, put on the uniform, and be there for the 0730 muster in. But they were exhausted. They didn't get much out of the training. And they might have been a danger to themselves and others if they're operating equipment or maintaining equipment without sufficient rest. So you are entitled to time off, not just from 0700 on Saturday to 1600 on Sunday, but you're entitled to leave the civilian job sufficiently early that you could travel to the place of your service, like your reserve center or NOSC as we call it now, and be in a fit for duty status. And same on the back end, as I said, you don't have to return to work until the first regularly scheduled work period on the first calendar day after you've completed the period of service, have safely traveled from the place of service to your home, and then another 8 hours for rest. If you are entitled to reemployment under USERRA and you've been gone for a substantial amount of time, the employer is required to provide you with training that you would have received if you'd been continuously employed. That can be very important, especially in some kinds of work like IT, information technology. You know, they say it changes 100% every 18 months, so that can be very important. Next slide, please. USERRA provides for disabled veterans. If you suffered a temporary or permanent disability during your period of service, you meet the 5 criteria, you're reemployed, but the employer is required to make reasonable efforts to accommodate your disability. And if you cannot perform that job, even with a reasonable accommodation, the employer is required to reemploy you in some other position for which you are qualified or can become qualified with reasonable employer efforts. Maybe Joe Smith cannot be a police officer anymore because he lost an arm and a leg in Iraq. But the employer is the city government, not just the police department. He could be trained, he could become a librarian, he could become a clerk in the tax office. It's important for those, not everybody who leaves job for military service comes back in exactly the same condition that he or she left. Next slide, please. There's what we call the furlough or leave of absence clause. If you're away from a job for service, drill weekend, annual training, voluntary or involuntary mobilization, etc., you're entitled during the period of service to the non-seniority benefits that other employees on non-military leaves of absence receive. There have been 4 recent cases covered in these law review articles from this year that I cite. If your employer grants paid leave for non-military reasons like jury service, the employer must grant paid military leave for a comparable period of military training or service. In other words, if people get 2 weeks of jury leave with pay, then you should get 2 weeks of military leave with pay for your annual training. This is a very recent development, very important for some reserve component members. Next slide, please. You're entitled to vacations, holidays, and days off. You do not generally continue accruing vacation from your civilian employer while you're away from work for service, but it's unlawful for the employer to make you use your vacation or annual leave during your period of service. You have the right to use it. If you have 30 days of vacation or annual leave in the bank when you go away for military service, you can use that 30 days during your period of service in order to get the double pay for a month. But that's your choice, not the employer's choice. Next slide, please. This is an important provision, 4316C1. If you're away from service, away from your job for uniform service, and you come back and you meet the eligibility criteria, you cannot be fired except for cause within 1 year after your proper reinstatement, if the period of service was 181 days or more. If the period of service was 31 days up to 180 days, you cannot be discharged except for cause within 180 days. This is different from section 4311. You do not have to prove discrimination. Just, hey, I was gone for military service. I met the 5 conditions. I returned to work on January 1st, 2022. I was fired on February 1st, 2022. The special protection period was still in effect. The employer has to prove I was fired for cause. This is to protect you from a bad faith or pro forma reinstatement, and to give you a reasonable time to get back up to speed in the job after you've been away for uniform service. Next slide, please. Next slide. There is an enforcement mechanism both for federal agencies as employers and a different enforcement mechanism for state and local governments and private employers. So you do have valuable rights under this law. It is enforceable. It's not just a nice thing to do. It's federal law. Next slide. I want to bring to your attention a Department of Defense organization established in 1972, before most of you were born, called Employer Support of the Guard and Reserve, ESGR. You probably have ESGR posters right there in your NOSC. They have a toll-free number, 800-336-4590. They have a website, www.esgr.mil. They have several thousand volunteers, maybe 1,200 of them called ombudsmen. Many of them are retired reservists themselves. They work with civilian employers and National Guard and Reserve members to try to work out problems, to try to persuade employers to do what the law requires. And indeed, many employers do more than the law requires. So keep ESGR in mind. If you're having problems, that's always a good first step. They may not get all cases resolved, but I bet they get 90% of them. And it's informal, it's non-confrontational, it's quick. Next slide. If that doesn't work, you can go to the Veterans Employment and Training Service of the U.S. Department of Labor. But you don't have to. If you can go directly to federal district court to sue a private employer or a state or local government, a local government, not a state government. But if you want free legal help from the U.S. government, you have to go through the Veterans Employment and Training Service of the U.S. Department of Labor. Next slide. The DOL Vets has subpoena authority. They have a duty to investigate your case. They will refer it to the Office of Special Counsel if your employer is a federal agency, or to the United States Attorney General if your employer is a state or local or private sector employer. Next slide. Next slide. There is no statute of limitations under USERRA. At least that was made even more clear in October of 2008. So there's no drop dead date. There is the equitable doctrine of latches. If you wait years and the employer can show the court that because so much time has gone by, because you inexcusably delayed in initiating the lawsuit or bringing the claim, and that records have been lost or destroyed, memories have dimmed, potential witnesses have died, the court may dismiss the case on the equitable doctrine of latches. Moreover, the longer you wait, the more difficult it is for you to prove your case. So I do not recommend that you sleep on your rights. If you have a USERRA claim or think you may have a USERRA claim, you need to check it out sooner rather than later and initiate the process to get relief. Don't wait 10 years to bring it up. Well, back in January of 2022, I came back and they wouldn't reemploy me. Don't sleep on your rights. Next slide. USERRA is a floor and not a ceiling. USERRA does not supersede a state law, an employer policy, a contract, a collective bargaining agreement between your union and the employer, or any of these things, if and to the extent that those other things give you greater or additional rights. But USERRA does supersede state laws, employer policies, collective bargaining agreements, etc., that purport to limit your USERRA rights or that impose additional prerequisites upon your exercise of USERRA rights. Next slide. In its very first case under the 1940 reemployment statute, that same Supreme Court case, Fishgold versus Sullivan Dry Dock and Repair Corporation, the court held no practice of employers or agreements between employers and unions can cut down the service adjustment benefits that Congress has secured the veteran under the Act. Next slide. Next slide. The Department of Labor has published regulations about USERRA in Title 20 of the United States Code. They were good in 2005 when they were promulgated. They need to be updated, but they are at least a place to start looking for what the law requires. Next slide. Next slide. Next slide.
Thank you, Captain Sam Wright, Judge Advocate General Corps, retired, for this amazing presentation on the USERRA Act and what it does for our sailors and all members of the Reserve Force National Guard. If you have questions, please don't hesitate to reach out to your Reserve Center staff. They will forward those questions over to Captain Wright, or you may look at the website that Captain Wright talked about at the beginning of the presentation. Thank you all and have a great day.